Hi, everyone. This is another installment of how to implement the relational mediation method. Now, we all know that any work that you do on your case should be a conscious effort to move the case forward. What does that mean? Well, it's more than just getting police reports, accident reports, photos of the scene, hospital records, and the like. Of course, these are important. You need these items to prepare pleadings, to move the case into litigation stage, to comply with the procedures that will make your case ready for the calendar and for trial. The same work is necessary, by the way, to prepare your case for resolution. Trial is but one resolution method. Others are direct discussion with the adjuster or the attorney, mediation, arbitration. These are all efforts that result in resolution of your case and a part of the same preparation. So we've discussed the relationship between the attorney and the client, the attorney and the adjuster, but a diligent adjuster and attorney is also going to develop a relationship with the court, with the witnesses, with the experts needed on the case. Now, much of this happens organically and can be developed just by proceeding along the litigation timeline, but not all of it. A lawyer must develop a relationship with everyone that will be involved in this case, and that also includes the mediator. Today, many courts are assigning cases. If you read the rules of this for the various courts in New York, you will see that it can be referred by the judge. It can be referred by court. You should take advantage of this system if you have a case pending in one of the New York courts, especially your personal injury cases. First of all, you've done the work during the course of the case to get it to this point. Second, the courts are using people who have credentials in the field that they're working on. For example, I worked for 40 years in the personal injury field prior to retirement, and now they've kind of brought me back in and allowed me to use all those years of experience in trying to resolve cases for other attorneys, newer attorneys, who this system did not exist when I was practicing. I wish it had. And I can't believe that you're not going to take advantage of this opportunity to work your case, to find out what's going on with how the other side is viewing the case, to have discussions with your client on a resolution scale, which is very important to have with your clients. This court ADR program is fabulous for you to really develop your case and determine if it is a case that needs to be tried or not. And this goes for both sides, plaintiff and defendant. However, if you are new to the system, you may get assigned a mediator that you don't know anything about. You should ask some questions. For example, if you have a personal injury case, you want a personal injury attorney, someone who knows the system from either side, someone who's had cases, someone who understands the problems associated with having a practice or with being an adjuster or the huge caseloads that exist. So it's important. How do you get to know the mediator? Let's just say you get assigned somebody. Well, you should make it your point to find out about the mediator. One, you should contact the mediator and initiate a discussion and say, hey, we've been assigned your case and I understand you're going to be fair to all parties, but I didn't know you. I thought it might be worth us discussing a little bit about you. That's one way. Two, if it was me, you could find information about me. I have a website. I have a record of working with attorneys, and you could certainly find that out by just speaking to the ADR people and say, I want to know a little bit about this mediator. In fact, they have a website, the ADR site, where they give you a little information about the mediator. One of the great ways to really develop a relationship with the mediator and for both sides is to do a pre-mediation discussion prior to the mediation. Now, not all mediators do this. I do because I think it's very important. Developing that relationship between the parties, between the adjuster, between the attorney, between the mediator and the parties. The absolute best way is to have a case before the mediator and learn how he or she utilizes submissions, pleadings, discussions, offers, demands. Now, I will tell you, there's no one way that I do a mediation. A lot of how I decide how to structure the mediation going forward is developed at the pre-mediations. And that is organic and can change from time to time. But there are some tried and true methods that we all try to use. I happen to believe in self-determination. And so I'm not here to just tell you, you go get this and you take this and you do that. No, you don't need me for that. You need me to try and pull out the arguments that are being made, try to make the other side understand your argument, and let them listen to what you have to say and make you listen to what they have to say. So work on developing the relationship. You can do that by having mediations with that particular mediator prior. And if you don't have prior, then you should make it your business to have a pre-mediation discussion with that mediator.